Sounds good. All right, you are Larry Fitzgerald Williams. And Mr. Williams, in cause number 25, DCCR 0985, is charged with capital murder. And Mr. Cashion has filed a motion asking that I reduce bond. We were here either last week or the week before. I've reset this case today to give everybody some time to get prepared on that motion. And Mr. Cashion, do you intend to call your client?
Oh, no.
Okay, you may call your first one.
Okay, so before I do that, Your Honor, you know, someone, she, and one of my witnesses, I want to can't you, right?
Absolutely. I don't typically require any. Jefferson County's not.
Notice this subtle but important moment. The judge immediately agrees to protect the witness's address. That's not just courtesy. In murder cases, courtroom streams can go viral, and witnesses often face real safety concerns. This is a quiet example of the court balancing transparency with protection.
Yes, sir. Absolutely. We don't need the guy addressing very rarely, especially with. Ms. Anderson and Mr. Williams, if you'll just kind of step around closer to Mr. Cashion, kind of right there. You're good right there, sir. And maybe you can come right up here in the front, please. Good morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
I want to be able to and you ever been on TV? And
ma'am, can you speak up so that I need to hear you in the court reporter needs to hear you. Thank you.
What did you listen? No, that's all right.
Little detail, big strategy. The defense is establishing Ms. Anderson as a credible, stable member of the community, business owner, lifelong resident, long-term ties. Why? Because credibility is everything when you're asking a judge to trust your family with a massive bond responsibility.
What do you do now? And that's the shield for life. I want you to honor. So, Mr. Williams, practice Tennessee, yeah, was he right? Yes, yeah. Yeah. Remember, you know a bomb contract is? You know what a bomb consists of? And you have to go to a bomb. And the bomb thing was sure what. And family and suddenly he has a bond $2 million. Right? And he wants to make that $10 million bond. And the $2 million bond also about medicine, like early on bonds. And also, the other bond has a strong right to what for? Okay, you have a cost $2 million,
$10 million. That's not a bond, that's basically the court saying, you're not going anywhere. Judges use ultra-high bonds when they believe the defendant is a serious danger or flight risk. So the defense's push for $50,000? That's like asking to turn a mountain into a pebble.
And, yeah, just like bond like $50,000. Yeah, family, maybe, property, money should work, share the law. You burn close on it. Yeah, like a family, close on. Then it's touch about would be willing to go along with the law.
I'm sorry, I can't hear you.
So,
I still didn't understand what you said at the end. Oh, he's in good standing.
have you ever known Larry not to feel important? And he was on the other part of the people. So, should he ever fail to get out, come to court? He always came to court every time, on time. There's never any problems. He came and showed up for us. And, calculate.
All right, thank you, Mr. Cashion. Mr. Smith, any questions of this witness? Thank you, ma'am. You can go back and have a seat. Any other witnesses, Mr. Cashion?
No, ma'am, but Your Honor, I would like to point out that family members in the courtroom.
Yes, sir.
Cashion Williams died. She was trusted in the courtroom. She would say the same thing. Ms. Kemp's as well. The Alicia Slade, who's also adult, she was from the same thing.
Thank you.
Prejudice is blind.
Mr. Williams, you can sit back around.
Prejudice is blind to get killed. Both of them killed. Since you're the punitive, and Mr. Williams, although he has issues with the court, and the system here never felt like it. And see, she was in court trial. She was getting all of his court reasoning. Shows that he is not ready to win. He's not ready to run. He's coming to court charged. The other court required to monitor the maintain location like the else. Does need to work well, but not. There's under housing. I think he's here. Maybe a monitoring for a few hours. So it's down the line.
Okay. Mr. Smith?
The statement closed during the line. It's Captain Martin. Based on the fact that he was coming up for trial, and Mark was on the good. He was also the victim of having assault. Very shortly before that was actually going to be called for trial. He decided to fled after fusion with Martin Fuji to be located. Shows that he is likely to run this. Give me a ball. Family of is also included in their life.
Here comes the punch. The prosecution claims he fled after the murder. In bond hearings, flight risk is the deciding factor. If a judge believes you ran once, even for a moment, that's usually game over. Notice how the defense immediately counters with a completely different narrative, that he was heading to his lawyer's office. Two sides, two stories, and only one of them will stick.
Your Honor, in regard to what said, Mr. Williams was locally in the trauma kind of way to my office. That was in and around the area. He's coming to my office. So he had heard of this report about is found alleged murder. He was not in the process, so he was process. So, process, right. So I think he was arrested and he was like, so he was.
All right, so obviously this case is state of this case precedes any modifications that happened in our legislation this last cycle that have come into law as of yesterday. One of those is actually that it is appropriate, and if someone is out on bond for a felony offense and the allegations are that they commit another felony offense, to have no bond, which is something that is more strict instead of more lenient with regard to bonds. I believe the fact that Mr. Williams has come to court when required obviously is nice and great, but the fact that he's the allegations are that, and it's their allegations, he hasn't been found guilty, but I am entitled to take into consideration the underlying facts of the case. And so based on the offense that he was charged with initially, the aggravated assault, based on the facts, new allegation is that the victim or the complaining witness in that case is now the victim in this alleged case. I do not find that
this is the moment everything tilts. Judges can consider allegations and underlying facts even without a conviction, especially when the same victim appears in multiple violent cases. Watch how she frames her decision, not emotional, not dramatic, just purely based on community risk. When judges talk about best interest of the community, the answer is almost always a denial.
it would be in the best interest of our community to grant the motion, and I am going to deny that motion.
And there it is, bond reduction denied. In legal terms, this is a hard stop. No matter how many family members showed up or how responsible the defendant was in previous cases, the alleged sequence of events outweighed everything. For the defense, that's a brick wall. For the prosecution, that's a clean victory.